just in relation to burials and as such, like in the rules and regulations in relation, Minister, to burials needs to be looked at in a more deeper manner as such. You know, I contacted the department actually not so long ago in relation to a constituent of West Cork who wanted to be buried in their own home grounds. Nobody, the local authority couldn't give me the information, the department couldn't, 2 different departments couldn't give me the information, and the people were, you know, very upset at a very delicate time in their lives. And I think that's an area that needs to be improved, that there needs to be some proper regulation as such in relation to burial grounds and where a person is to be buried, whether that's in their own lands or not as such. And I'd appreciate, Minister, that you take that opportunity, because it is an upsetting and a difficult time for people as to where their loved ones can be buried at a specific time, and somebody needs to have proper regulation over that going forward. Thank you.
Minister, on Amendment 14, 15 and 16.
Thanks, Deputy Collins. I don't think I'm going to be able to assist you in terms of this legislation is solely dealing with burials relating to mother and baby and county home institutions and the like. I think perhaps engagement with the Minister for Housing and his department is the best way, but I'm unable to help in terms of what this legislation, which is very specific, is about. I'm not in a position to support the amendments put forward by the deputies for the same reasons I outlined at committee stage. I think it is important to recognise that excavation is not a desired option in every circumstance. And I've met families and survivors, and I'm deeply aware that for some family members, the graves of their loved ones, these site
investigation. What I emphasised, just for clarification.
No, I wasn't specifically referring to your. There was
well, look, I'm not trying to be disorderly. Just I'm trying to.
A number of contributions made. So I have met many families and survivors, and as I say, for some of them, they regard these sites as a grave site and do not wish to see them disturbed at this stage. And they would see it as a violation of the sanctity of the remains of their loved ones, and their preference and these are in some circumstances, and I do acknowledge that on certain sites the preferences are different among survivors, but in some circumstances the preference is a more memorial recognising and marking the burial site. And this legislation, which as we know is not site specific, it has to be sufficiently flexible to allow government to take account of differing circumstances and differing views which may arise in the future. And I have considered the PLS recommendations on this specific issue, and in light of these, the provision in the legislation has been amended to specify that the government must have substantive reasons to form the view that memorialisation of the burials on the land without further intervention is the more appropriate route to go. So this provision is not designed to allow the government to refrain from intervention. The government will have to set out clearly the reasons for choosing memorialisation, and the rationale has to be sufficient and reference to some technical difficulties which would be such to adequately justify the decision not to make an order. In terms of Amendments 15 and 16, Section 7 specifies that the government may establish the office for a specific period in order to allow it to intervene at a site associated with an institution which contains manifestly inappropriate burials, in order to help ensure the officer's effective operation and to adjust to the evolving situation at a particular site. The relevant minister may need to alter the functions of the director, and as such those proposals would need to be approved by government. I would like to reiterate that the provision is not designed to prevent a director from undertaking a certain activity. In fact, any such proposal is based on information provided by the director, him or herself, which must be taken into account by the minister. And the provision in effect allows for adapting the work of the office in line with the request from the director. And this in turn reflects the reality that at the outset of an intervention, there is likely to be a high degree of uncertainty as to what the director and their office will encounter. If the provisions were removed as suggested, the director may be legally required to perform a function that cannot in reality be implemented. For example, it is possible that the function of an identification programme is assigned to the director at the outset, but if there were no living relatives willing to come forward to participate in that programme wouldn't have any function. And in this case, an identification programme might no longer be feasible, but if we hadn't the capacity to amend the range of functions that the director director could take place. The director would still be legally obliged to undertake the DNA identification programme, even if it was no longer practically feasible to do.
Thank you, Minister.